Christa. Is this the type of information that should be put in front of this jury?
Never, 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 never. And I think from one, it's character evidence. In all 50 states, there's a character evidence rule. And it's not permitted unless the attorney in that piece was correct, unless there's some relevance to it. And you'd have to show, some pretty good relevance to it. Not some attenuated relevance. Now, we saw, character evidence get admitted about George Floyd in this in the Derek Chauvin trial, and I think that backfired. So when I say never, I think that defense attorneys should be careful when they decide whether or not they want to bring in character evidence of a victim, because it just makes you look like you're piling on to a victim. This guy deserved to die? Really? Is that what you're going to be arguing? I feel like it's just a real bad idea all the way around. What you need to do is focus on what has happened in this particular case. And in this particular case, I doubt that his mental health or his, driving on a suspended license plays any role in what the McMichaels are accused of doing here.
Well, let me tell you what the defense attorneys are arguing here, Christa. They're saying that it goes to his prior bad acts go to his intentions in the vacant house. Remember, they had seen him in the vacant house. It's unclear if they recognized him exactly, but I think they're going to claim that they had seen him on some closed-circuit video in a vacant house a couple of times, right? So they're saying it's going to go to his intention, showing he had this sort of criminal mind, and then also his aggressiveness and intentions in the confrontation, which goes directly to the defense. And so to say a defense attorney should think twice about it is, if I'm a defense attorney, I'm saying, I want to show that this guy has an aggressive nature in many ways, has a felony conviction, because that plays into why my particular defendant decided to act the way he did, or how he felt the way he did when he was, quote unquote, attacked by Arbery.
I understand what you're saying, and I get that. But what I think in this particular case, you've got whether or not they saw him, in the house on closed circuit TV. How does his mental health? That's kind of attenuated argument. I think, to show that his mental health status had something to do with why he was in the house. It does, it's about their conduct, right? And whether or not it amounted to self-defense. I hear you on that. But I still think it's a stretch, because what you're looking at here is dangerous for a defense attorney to argue that his mental health was the reason for his aggressiveness. You've got 3 men potentially with guns coming after you, chasing you. You're not going to fight back.
Yeah, and we found out earlier that we didn't know this at the time, but we found out now that Roddy Bryan, who was following behind, had actually hit him with his car to keep him from leaving the neighborhood in a different direction. So he had already known a form of aggressiveness from this group that was following him. So he was aware something was going on. But I want to touch on something you mentioned and dig a little deeper. You talked about getting the angst of the jury. We heard that also in the piece as well, one of the attorneys talking about it. Tell me about that in your experience, that jurors really, they reject this idea that when people try to sully the victim in cases?
I do. I think that, victims are already sympathetic because something bad has happened to them. Either they've been killed or they've been whatever the crime is. And so the victim is already a sympathetic figure in your case. And if you're going to be attempting now to say that this person has all of these bad character traits, you have to be careful how you use it, and you have to make sure that it has that high amount of relevance. Otherwise, you have to tie it together for the jury so the jury can understand and appreciate that. Otherwise, what the jury is hearing is you commenting upon some bad character traits of someone who is now deceased. And so I think that it's a very tricky situation. We even see this in our civil cases. When you attempt to call a plaintiff a liar or a malingerer or something like that, jurors sometimes they want to know about what's happening here. And they really don't like it when people start throwing, a bunch of other stuff into it to muddy the waters.
Fair enough. An interesting point. In this case, they will not be able to call Ahmaud Arbery a victim. It was a motion made by the defense, and it was granted by the judge. All right, stand by, Christa. A lot more to discuss. There is really a lot more to talk about with this particular